Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. So one of the things that has happened recently is I've been getting a lot more comments and people have been asking a lot more questions, and it's sometimes hard to keep up with that, but I'm doing the best I can. A lot of the time that I have spent in the last couple of days has been looking at these comments and thinking, wow, that'd be a good video, and that'd be a good video, and that'd be a good video. So I'm starting with one that I found today from Paul. And Paul says, I've been waiting for an analysis about this. Can you explain why he has no right to bond? Meaning Jeffrey Williams. I can do that. He goes on to say, also, JD, can you explain why the judge is biased or has the appearance of bias? And I'm certainly going to try. So first off, if I said he had no right to bail, I misspoke. He certainly has a right to bail, as that right exists in the Constitution. However, there are so many impediments to him getting that right fulfilled that, and for all practical purposes, he's not going to get bond because of the crimes that have been charged. One of the things that prosecutors sometimes do, and I don't know that this is what's happened here, but it certainly could be, prosecutors overcharge. They'll charge robbery, they'll charge grand theft, they'll charge 4 or 5 other felonies in an indictment, and then what they really want is they want you to plead to, the most serious crime, armed robbery. And then they drop all of the other ones. But until such time as they drop the other ones, you got all these felonies on your charge sheet, and the judge has to consider all of those in determining whether or not to grant you bail. When it looks like you're a serial offender because you got all these charges, a judge is not going to go out on a limb and let somebody go out on bail if he thinks it could come back to bite him later on. So there's that part of it. But let's look at what the statute says. I think you'll see in looking at the statute that it's a serious uphill climb for Jeffrey Williams to get any kind of bail. This is from the Georgia statute 17-6.1, and it says the following offenses are bailable only before a judge of the Superior Court, which is Glanville: treason, murder, and then there are a couple of sex-related crimes, and then armed robbery, home invasion in the first degree, aircraft hijacking, and hijacking a motor vehicle in the first degree. So carjacking is certainly one of those things that would be considered bailable only before a Superior Court judge. We're going to skip all over the others. There's a whole bunch of them listed in that statute, and we're going to go down to paragraph B1 because it makes an important point. All offenses not included in subsection A of this code section, inclusive of offenses that are violations of local ordinances, are bailable by a court of inquiry, which is essentially a magistrate court in other jurisdictions, except as provided in subsection G of this code section at no time, either before a court of inquiry, when indicted or accused, after a motion for new trial is made, or while an appeal is pending, shall any person charged with a misdemeanor be refused bail. When determining bail for a person charged with a misdemeanor, courts shall not impose excessive bail and shall impose only the conditions reasonably necessary to ensure such person attends court appearances and to protect the safety of any person or the public, given the circumstances of the alleged offense and the totality of the circumstances. So not every time you smack somebody in the nose is that a felony assault. A lot of times it's a misdemeanor assault. But by virtue of the fact that you have popped your neighbor in the nose because he said something about, your dog or your wife, that's still an assault and it's still a battery. And as a result, to protect your neighbor, they're going to impose conditions in the bail. They're going to say, yeah, you have to post $1,000 for bail, and you have to stay away from your neighbor. Those are the kinds of conditions that they're talking about. And they do that because there's no reason to keep you in jail for months and months when it's a misdemeanor. Everybody should have a right to bail. Now, just because you have a right to bail doesn't mean that a bail bondsman is going to bail you out, because he has to assess his risk. And his risk is what happens if you don't show up. So there are a number of things at issue here that deal with all of these factors. And as a result, just because you have the right to get bail doesn't always mean that you are going to get the bail. Now, note that this section of the code shows a clear break between minor crimes like check kiting and simple assault and major crimes like murder, assault with a deadly weapon, aggravated assault, those sort of things. Georgia statutes first state what kind of standard a defendant must meet in order to be granted bail. In other words, what conditions do you have to satisfy for the judge in order to be granted bail on any kind of felony? And here's what the court says. A court shall be authorized to release a person on bail if the court finds that the person poses no significant risk of fleeing from the jurisdiction of the court or failing to appear in court when required. Poses no significant threat or danger to any person, to the community, or any property in the community. Poses no significant risk of committing any felony pending trial, and poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. Then it specifies what the judge must consider when setting bail. When determining bail, as soon as possible, the court shall consider the accused's financial resources and other assets, including whether any such assets are jointly controlled. So, for example, if somebody has a house in the jurisdiction, real property in the jurisdiction, they are less likely to flee because they own property there. And that is an important consideration for the judge. It also is an anchor that makes it less likely that somebody is going to skip out. In many cases, they will, in order to satisfy the bail bondsman, put their house up as collateral, which means that if they fly the coop, there goes the house. So what kind of assets they have and where they're located, whether they're property, those are important considerations in terms of an anchor to the community. But they also are important to consider, particularly if somebody is a multimillionaire. It makes it possible for them to just pick up and fly to a jurisdiction that does not have an extradition treaty with the United States. One of those is El Salvador, the other is Vietnam. And if some, that's what Wendy Adelson's mom, Donna Adelson, she was going to fly to Vietnam. They were walking out to the airplane as it got ready to take off when the FBI nabbed her and brought her back. All of those kinds of things are important because when you do have assets, disposable assets that you can use to fly the coop, the court has to take that into consideration because it may mean that he needs to set a higher bond, or he may need to, for example, take your passport. So that's an important consideration. If you have the resources necessary to flee the jurisdiction, that may require additional restrictions on your movement after you are granted bail. So in addition to that, the accused's earnings and other income. Is the person bringing in income? Are they in a job where if they don't continue to earn income, their financial obligations like child support might fall in arrears? And if that's the case, that would mean that children would suffer. So the court has to take that into consideration. And of course, the purpose of bail, which is to allow someone the presumption of innocence. And of course, the court also can consider any other factor it deems appropriate. And that's a pretty broad brush statement of saying the judge can say, I don't like the way you look. Hopefully he wouldn't do that on the basis of race, creed, color, sexual orientation, anything like that. But, he could look at your criminal history and say, well, you've always showed up for trial, but now you've gotten to a point where you are in a much more serious crime, and I'm just not going to grant you bail. Again, that's reviewable, but usually an appellate court is not going to step over a trial court and grant bail. So here's the next section. and this is what really hammers Mr. Williams in this case. If the person is charged with a serious violent felony and has already been convicted of a serious violent felony or of an offense under the laws of any other state of the United States, which offense, if committed in this state, would be a serious violent felony, there shall be a rebuttable presumption that no condition or combination of conditions will reasonably assure the appearance of the person as required or assure the safety of any other person in the community. As used in this subsection, the term serious violent felony means a serious violent felony as defined in Code Section 17-10-6.1. And that code section provides that the following are serious violent felonies: murder or felony murder, armed robbery, kidnapping, and with the exception of kidnapping, the RICO predicate crimes, which are also charged in the indictment, include murder and robbery and are serious violent felonies. So what does a rebuttable presumption mean? Well, it means that in the absence of clear and compelling evidence that supports the granting of bail and that negates the presumption, no one is getting out of the slammer when these crimes are charged. So colloquially, we're going to say no bail for capital murder or capital crimes. Now, that code section is stated in the conjunctive, not the disjunctive. So theoretically, Mr. Williams would have to have been convicted of another serious violent felony for that to affect no bail in this particular case. But a lot of times courts look at that section and say, even though it's in the conjunctive, we're going to consider that an or and not an and. I know it doesn't make any sense, but a lot of times that's the case. And I seriously think that when you have anybody charged with murder and they have assets, particularly sufficient assets to flee the jurisdiction, the judge is not going to grant bail. Now, Paul also asks why I think the judge is biased. And I'm not certain he actually is biased. I only have his actions to go by. Only he knows for sure if he's biased. But some of his actions indicate a predisposition to favor the state. And that means that in terms of this particular prosecution, he is not the proper judge because he has this predisposition to favor the state. For example, holding a meeting that both the lawyer and, who is Love, and the judge, who's Glanville, knew to be prohibited, the lawyer by the ethical code that binds lawyers, and the judge by the ethical code that binds judges. Both those people knew that the ex parte meeting was not proper. And the fact that they conducted the meeting in order to bully a witness into not asserting his right to testify is an indication, at least to me, that the judge is not playing fair with the defense, because the defense has a right to be present at every critical stage of the proceeding. And certainly when you are trying to convince somebody to testify or compel them to testify because they've been granted immunity, anytime you do that, that's a critical stage of the proceeding. And they absolutely had a right to be there because many of the things this guy said are what we would traditionally call Brady material. He told the prosecutor, if you ask me to testify, I'm going to testify that I killed this guy. Well, that's Brady material as to everybody else who's charged in that crime. And because he revealed that in this secret meeting, well, which is no longer secret, of course, but because he essentially revealed that, it's Brady material, and the prosecutor had an obligation, a rock-solid, absolute obligation to disclose that to the defense attorneys for the parties involved, and she did not do that. Basically, he had to find out through a third party. And the failure to provide that information as soon as it was available is a Brady violation, and it would cause this entire thing to come back. And it probably should cause this entire thing to come back. The canons of judicial ethics also say that a judge should avoid even the appearance of impropriety. And that's an important rule, because if you have a judge who's taking shortcuts It looks like the judge might think he has better things to do than preside over a fair trial or ensure the fairness of a fair trial. And it's this appearance of impropriety that I think is the biggest concern here. A smarter judge, when this issue was raised, would have by this point stepped aside. He would have said, okay, I understand why you're upset. I understand why you think it might be necessary because it does look like maybe I favored the state here. I get that. I'll recuse. And he should have done that because no judge wants an appellate court jumping in and saying, hey, you should have recused. It's effectively a black mark on your judicial record. So there's that. That's why I think the bias issue is so important. Getting back to Mr. Williams, he has multiple strikes against him as to bail. First, as noted, he's charged with violent felonies. He's part of a criminal organization. Again, that's his allegedly. It has not been proved. I don't think the evidence comes close to proving it at this point. There are murder charges in the indictment, and these all require the rebuttable presumption to be met, at least in my thinking they do. Even though he hasn't been convicted of anything else at this point, they do require the rebuttable presumption to be met, if not from a statutory point of view, from the point of view of a judge who's thinking about granting bail. So what kind of evidence would establish that he poses no significant risk of fleeing? He's got the money. Or failing to appear in court. Again, he's got the money to walk away. What evidence establishes that he poses no significant threat or danger to any person, to the community, or to any property in the community? Well, I mean, they're hiding witnesses from him. They're trying very hard to keep people from being intimidated. That, to me, would suggest that there's some risk there. Or that he poses no significant risk of committing any felony pending trial. Again, I don't know that that is a showing that he can make. Or that he poses no significant risk of intimidating witnesses. Woody's teeth are already chattering from fear, and he hasn't really even been touched at this point. Remember, they're hiding him, Woody, because they thought he might experience high-velocity lead poisoning if he made himself a target. And then Williams is a successful rapper. As I said, he has financial resources and other assets, makes it easier for him to get bail, but it also means he could fly the coop to another country and display his middle digit to the government from across the waves. In short, the statute stacks up against Williams getting bail. And if that wasn't enough, let's say the court, because it's gone on this long, decides to grant bail of $2 million. He probably isn't liquid enough to put that up as bail, and he probably owes, a lot of money to his lawyer. So he'd go to a bondsman, and a bondsman would have to evaluate whether and to what extent he was likely to flee. And if he fled, is the bondsman going to be on the hook for the $2 million? Absolutely he would be. Is he going to put that money at risk by issuing the bond without a whole lot of collateral? Probably not, and maybe not even then. So, Paul, that's the explanation, and that's what I have for you today. If you have any questions, drop them in the comments down below. And like, share, subscribe, all that stuff. If you could, go out of your way today and do a kindness for someone. Yesterday, my wife went to work without taking her lunch, so I jumped in the car and took her lunch so she would have something to eat over the lunch hour. And I took my lunch up there and ate with her at the same time because that's the kind of thing that she enjoys, and so I do that. It never hurts to do a kindness. And then, after you've done a kindness, maybe come on back tomorrow and join us down here at the beach, and we'll talk about something else fun. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.